The state in the Senzo Meyiwa murder trial has unveiled a new evidence, including photos that have never been seen before. According to the state prosecutor advocate, these photos are linked to accused number 3, who is represented by Advocate Charles Mnisi. Meanwhile, Judge Ratha ruled in favor of the state to introduce additional photographic evidence. However, despite his ruling, the defense counsel expressed frustration. It alleges that the state was reckless for not bringing the photos and the evidence in chief. Now, to discuss this further, we're joined by a legal expert at the Law Clinic, University of Johannesburg, Elton Hart. Elton, thanks so much for joining us. I mean, how does the introduction of these new photos impact the overall case and the defense's strategy?
Now, I think if you look at what the state is trying to do is to actually create further circumstantial evidence to support the narrative that they're trying to paint to the court. Because clearly it is evident that certain crucial photos, the metadata is not available. And it's clear from the defense versions that these photos were taken in 2018 and 2020 respectively. Now, the state is trying to paint the picture that these photos was taken in 2014 on 26 October when Senzo Meyiwa was killed. But I already can sense that there is discrepancies in these photos and also dealing with the authenticity and the genuineness of these photos. But also, I could see that the judge in this case is more open when the state makes these funny types of requests to introduce additional evidence. If the defense is coming with such a request, then he's quickly to chastise them and overrule them, but he's more forthcoming when the state makes requests. And I think this is some of the things that the state will argue at a later stage. And I think if a ruling is found, or it's ruled in against the accused person, they will take this on appeal.
And what are the legal procedures and standards for introducing new evidence at this stage of the trial?
Firstly, to introduce evidence, you need to show that it's relevant to the issue at hand. And once you show that it's relevant, you need to show that this evidence is admissible, which means it should not violate the accused person's fair trial rights. And thereafter, the court needs to now look at the genuineness and the authenticity of these photos. So that is, and they have to bring an application to show that they were not aware that this evidence exists, because it's in exceptional circumstances that the court allows this. If you had these photos from the onset and you willfully chose not to disclose them, which I think is what happened here in this case of the state, they had the phones, they had the downloads, they had everything, and they deliberately did not, or they opted not to disclose them. And for me, the judge was supposed to not allow them, but he allowed them now to bring those photos in. And this is going to be prejudicial to a certain extent, because now the accused needs to show that these photos were taken on a different date. It places an extra burden on them. And I think that was not fair. The judge should have told the state that you had your shot to introduce your evidence. You did not, unless you're going to call another witness that can testify and bring in who has not yet testified.
And given that Judge Ratha has ruled in favor of the state to admit the photographs, what are the implications if the defense feels the evidence was introduced recklessly or inappropriately?
They can, at the end of the case, to say that the court should actually exclude and ignore this evidence based on the reasons I mentioned, to say that the state had an opportunity, they did not show, and they chose. They cannot now be allowed a backdoor to actually sneak in additional evidence after they've heard what is the defense narrative or position pertaining to certain evidence that was already put against them. Now they're trying to actually sort of half cover the openings that they left open, that the defense actually explored, to say this is why we say we did not commit this offense. So here it was now, they were given a second chance to actually remedy the mistakes that they made in their first attempt when they called these witnesses.
Well, we will just continue. All eyes are definitely on the case as we see how this unfolds. And many thanks for doing this with us, Elton Hart. He is a legal expert at the Law Clinic, University of Johannesburg. Once again, thank you.